The 10th Amendment, balancing state and federal power and reserving power to the people. The 10th Amendment to the U.S. Constitution is one of the most important and debated laws in American history. It says, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." This simple sentence has shaped American government for over 230 years, but its meaning has changed dramatically over time. Thomas Jefferson considered the 10th Amendment to be the foundation of the Constitution. In his February 15, 1791 opinion on the constitutionality of a national bank, Jefferson warned, "To take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of a boundless field of power, not longer susceptible of any definition." In 1787, American leaders met to amend the Articles of Confederation, as that system wasn't working. Instead, they created a new constitution, giving the federal government more power. Many Americans worried the proposed federal government would become too powerful and endanger freedom. Despite this, on September 17, 1787, the Constitution was sent to the states for ratification. Two groups formed: Federalists who supported the Constitution and Anti-Federalists who opposed it as dangerous. Anti-Federalists like Patrick Henry, Sam Adams, and George Mason worried the Constitution placed no clear limits on federal power. Patrick Henry said, "If we trust our most important rights to guesswork, we will be in serious trouble." The Federalists, led by Alexander Hamilton, James Madison, and John Jay, argued that the federal government only had powers specifically enumerated in the Constitution. In Federalist No. 17, Hamilton articulated that states would keep control over people's daily lives, like local courts, farming rules, and family matters. In Federalist No. 45, Madison explained that the federal government's powers were few and defined, while state powers were numerous and indefinite. The Federalists promised that states would control important areas like religion, education, local government, marriage and divorce, property ownership, and business licenses. The Anti-Federalists wanted these promises written into the Constitution, not just talked about. To get the Constitution approved, Federalists promised that if states approved the Constitution, they would immediately add amendments to protect individual rights and state authority. Several states only ratified the Constitution because of this guarantee. When Congress met in 1789, James Madison kept the Federalists' promise. He proposed 19 amendments to the Constitution. What became the 10th Amendment went through several changes during congressional debates. Madison's first version said, "The powers not delegated by this Constitution, nor prohibited by it to the states, are reserved to the states respectively." Two important changes happened during the debates. First, some congressmen wanted to add the word "expressly" before "delegated." This meant the federal government could only do exactly what the Constitution specifically said, and nothing more. The Federalists opposed this, and won. Second, Congress added the phrase "or to the people" to make clear that all powers belong to citizens themselves, and the people were delegating power to government. Congress reduced Madison's 19 proposals to 12 amendments that were submitted to the states. On December 15, 1791, Virginia became the 10th of 14 states to approve 10 of the 12 amendments, thus adding the Bill of Rights to the Constitution. The 10th Amendment is designed as a rule of construction, a principle that guides courts and lawmakers in reading the Constitution's sharing of power between federal and state governments and creates a presumption about how to understand the Constitution. As a rule of construction, the 10th Amendment establishes that federal powers are limited and enumerated. The federal government only has those powers specifically granted by the Constitution. State powers are presumed to be retained, unless the Constitution clearly prohibits it or grants exclusive authority to the federal government. States retain their traditional authority. Ambiguity should favor state authority. This interpretive rule was meant to direct court analysis of federalism questions. When Congress passes a law, courts must determine whether it falls within an enumerated federal power. The 10th Amendment means doubtful cases should be resolved in favor of state authority, unless a clear constitutional command supports federal jurisdiction. The amendment doesn't create rights or powers. It establishes the lens for reading constitutional provisions, emphasizing that federal power requires justification, while state power requires no special authorization. At first, the 10th Amendment worked as intended, limiting federal power and protecting state authority. This changed dramatically in 1819 when the Supreme Court decided McCulloch v. Maryland. Chief Justice John Marshall noted the 10th Amendment doesn't include the word expressly before the term delegated. Marshall wrote this meant that the federal government had implied powers with authority to do things not specifically listed in the Constitution, if necessary to carry out listed powers. This greatly expanded federal power and weakened the 10th Amendment's protection of state authority. The Civil War amendments changed the relationship between federal and state governments. The 13th Amendment ended slavery. The 14th Amendment required states to treat all citizens equally, providing due process to everyone. The 15th Amendment protected voting rights. These amendments gave the federal government authority to override state laws in many areas, especially civil rights. During the 1930s and 1940s, the Supreme Court allowed the federal government to expand its power dramatically. The worst blow came in United States v. Darby, 1941, when Justice Harlan Stone said the 10th Amendment was basically meaningless. He said it just stated the obvious without providing any real protection. The court allowed federal regulation of nearly anything affecting business between states, which turned out to be almost everything. Anti-Federalist fears had come true. The federal government had taken control of many areas the Federalists had promised would stay with states. In the 1990s, the Supreme Court began giving the 10th Amendment new life. Chief Justice William Rehnquist's court created several important rules that protected state power. The anti-commandeering doctrine came from New York v. United States, 1992. This rule said the federal government cannot force state governments to carry out federal programs. Justice Sandra O'Connor explained that the federal government may not compel the states to enact or administer a federal regulatory program. The coercion doctrine came from a 2012 Obamacare case in which the court said the federal government cannot use funding threats to force states into accepting federal programs. The court struck down the requirement that states expand Medicaid because the federal government was threatening to take away all Medicaid funding if states didn't comply. Today, the 10th Amendment has some meaning again, but it's weaker than what the Federalists originally promised. The federal government controls many areas that were supposed to stay with the states, including much of education policy, environmental rules, healthcare regulation, and business regulation. States have begun to fight back. Some have passed laws trying to exempt state-made firearms from federal regulation, and some have resisted federal education standards. Many states have legalized marijuana despite federal prohibition. The 10th Amendment was designed to answer a basic question about American government. How should power be divided between federal and state governments? Despite the 10th Amendment, the debate continues. People who favor strong federal power argue that national problems need national solutions. The federal government can protect rights better than states, and many issues cross state boundaries. People who favor strong state power argue that local government is closer to the people. States can try different approaches to problems, and the Constitution was meant to limit federal power. These questions are as important today as in 1791, ensuring the 10th Amendment will continue to play a significant role in American law and politics. Help combat constitutional illiteracy by liking and sharing this video and subscribing to Constitutional Sound Bites.